Hello everyone, I am Prachi Bhardwaj and I welcome you to the 59th episode of the SCC Online Weekly Rewind, where you will get some quick bites on interesting legal updates from last week. Also, don't forget to watch the video till the end to find out the winners of this week's SCC Online quiz. This week's top story has to be the one where the Supreme Court came to the rescue of the Anganwari workers and helpers tirelessly working at the grassroots level. The court has held that the Anganwari workers and helpers are employed by the state government for wages in the establishments to which the Gratuity Act applies. Hence, they are entitled to the payment of gratuity. The court also observed that the Anganwari workers and helpers have been entrusted with the important task of providing food security to children in the age group of 6 months to 6 years, pregnant women, as well as lactating mothers, apart from rendering preschool education. And for all this, they are being paid very meager remuneration and paltry benefits. Therefore, it is high time that the central government and the state governments take serious note of the plight of Anganwari workers and helpers who are expected to render such important services to the society. Now moving on to some more stories from the Supreme Court. In a case where an employee had produced a fake certificate for seeking employment, the Supreme Court has held that producing false or fake certificate is a grave misconduct and dismissal of service is a justified punishment in such cases. In the case at hand, while the disciplinary authority had imposed a punishment of dismissal from service, the Bombay High Court had directed reinstatement of the delinquent officer without any back wages and other benefits. The Supreme Court, however, agreed with the disciplinary authority's decision and observed, the question is one of a trust. How can an employee who has produced a fake and forged mark sheet or certificate, that too at the initial stage of appointment, be trusted by the employer? In a long-drawn battle between the Life Insurance Corporation of India and its temporary employees over claim for absorption, a 3-judge bench of Supreme Court has appointed a 2-member committee to carry out fresh verification of the claims of workers who were working between 20th of May 1985 and 4th of March 1991 and who claim to have been employed for at least 70 days in Class 4 post over a period of 3 years or 85 days in Class 3 post over a period of 2 years shall be carried out. Finding the report of the previous committee faulty, the Supreme Court observed, a public employer such as LIC cannot be directed to carry out a mass absorption of over 11,000 workers on such flawed premises without following a recruitment process which is consistent with the principles of equality of opportunity governed by Articles 14 and 16 of the Constitution. Such an absorption would provide the very backdoor entry which negates the principle of equal opportunity and fairness in public employment. Read all about the newly formed committee and its tasks and timelines on the SCC online blog. Now let's walk through some stories from the High Courts. Stating that two-finger test cannot be permitted to be continued, the Madras High Court has directed the state government to ban the practice of two-finger tests on victims of sexual offences by the medical professionals. The court observed that it is necessary for us to put an end to the practice of two-finger tests. We find that the two-finger test is being used in cases involving sexual offences, particularly on minor victims. In a matter wherein an advocate alleged that the court was giving priority to certain matters and to certain advocates, the Bombay High Court has observed that an advocate, as an officer of the court, is under an obligation to maintain the dignity and decorum of the court. There is no room for arrogance and there is no license to intimidate the court, make reckless accusations and allegations against a judge, and pollute the very fountain of justice. Stating that great power comes with greater responsibility, the division bench of Bombay High Court has expressed that the expectation of responsible behavior or responsible conduct from those persons who are active in public life cannot be an extra expectation, but would be a basic one. The High Court stated that the declaration of the petitioners that they would recite religious verses either in the personal residence of another person or even at a public place is firstly an encroachment upon another person's personal liberty, and secondly, if a declaration is made with particular religious verses would be recited on the public street, the state government is justified in carrying an apprehension that such act would result in disturbance of law and order. Expressing that attempts to circumvent or undermine judicial decisions need to be viewed seriously in order to ensure that the functioning of our country is unhindered, especially during turbulent times, the Delhi High Court has held that it is only the rule of law which not only cements the civilized functioning of a country but also drives a country towards progress and development. With regard to contempt, the court observed that the underlying purpose of the law of contempt is meant to serve public interest and build confidence in judicial process. This flows from how the functioning of a democratic society is sustained by the rule of law, and willful violation of the same would enable anarchy. To read the full report, please check out the SCC online blog. Now on to some legislation updates. The International Financial Services Centres Authority has issued a detailed framework for fintech entity in the IFSC in order to develop and regulate financial products, financial services and financial institutions in the international financial services centers, and to encourage promotion of financial technologies across the spectrum of banking, insurance, securities and fund management in IFS. SEBI has issued the SEBI Custodian Amendment Regulations 2022 to amend the 1996 regulations. The amendment modifies Regulation 8 dealing with procedure and grant of certificate and inserts Clause 7 to provide that a custodian holding a certificate of registration as on the date of commencement of the Amendment Regulations 2022 may provide custodian services in respect of silver or silver-related instruments held by a mutual fund only after taking prior approval of the board. On April 21, 2022, the Central Board of Direct Taxes has issued the Income Tax 9th Amendment Rules 2022 to amend Income Tax Rules 1962 and introduce conditions for furnishing return of income by persons referred in Section 139 Clause 1 of the Act. And now, on to the most awaited segment of this episode. This week in the SCC online quiz, we had asked, privacy comes under which head of the curated topics on the SCC online web edition? The correct answer is constitutional law. Unfortunately, we did not receive any correct answers this week. But don't worry, We'll come back with another quiz next week. That's all from this week. Till then, stay tuned to the SCC online blog for the best analytical legal news.